Good afternoon. It's obviously been a long afternoon and it's beautiful outside, so thank you for being here in the room, and hopefully we can impart some really important information that will be helpful to you, your startup, your scaling up, regarding intellectual property. My name is Donna Rauch, and I am with an organization, a nonprofit called LegalCORPS. We are located in Minneapolis, and our founding mission is to provide transactional legal business assistance to entrepreneurs, startups, nonprofits, and inventors. So we've been doing that for almost 20 years. The Inventor Assistance Program, which is what I'm a part of, started in 2011 at the request of and with encouragement from the United States Patent and Trademark Office. So we have been working with independent inventors, and again, the mission of the program is to get access to inventors who would not have the resources to patent their innovation. So it's been an exciting ride, and that program is in its 12th year, and I have with me today 2 volunteers from that program. The way LegalCORPS works is we do the intake for our clients, and then we match them with attorneys that can help them. And in the patent process, having an attorney to draft, file, and prosecute your patent is a significant savings. LegalCORPS offers 3 different models of service. One, the first is educational events, much like today, and we have those throughout the year on various topics. Our website, which is legalcorps.org, has an event calendar, and that's where you can find what is coming up. The second one is brief advice clinics, and there are probably 20-some every month. 5 of those are intellectual property specific, and what that means is these are private one-on-one consultations with an attorney, privileged and confidential. And for intellectual property, it means you can talk about your innovation or your invention or whatever you have and ask questions, because to be real, we don't know what we don't know, and intellectual property can be a big black hole. So those brief advice clinics give you a chance to ask questions, and I always tell people the point is to find out what your next best steps should be. The attorney that you're consulting with isn't going to draft something or impart, this is the legal advice, but they are going to be able to help you identify your best next steps. And as startups and entrepreneurs, I know that that can be very challenging and extremely important. So the third model of service that we can provide is full representation. For the Inventor Assistance Program, that is drafting, filing, and prosecuting a patent application. So for that kind of service, there are requirements that must be fulfilled, including financial limitations. So I'm happy to answer any questions later on. Right now, I want to move us on to the meat of the session here so that you can learn more about intellectual property and patents in specific, and how to think about your invention and is a patent necessary. So I'm going to turn it over to my 2 volunteer attorneys who are with Schwegman, Lundberg, and Westner, an IP firm located in the Twin Cities, and you may start.
Thank you. We'll be talking a little bit about the patent system, a bit about trademarks, copyrights, and trade secrets, but we'll, as Donna mentioned, do a deep dive into patents, and we'll be available to answer questions that you have along the way or after the discussion. But as Donna mentioned, one of the ideas here is to help you identify your best next step. If you have an idea, what do you do with that? And that's essentially what we'll be talking about today. This is a plan of attack here for today's discussion. We'd like to talk about intellectual property generally and what you do with your intellectual property, what you do with your idea, and then what goes into a patent application, and also to what to expect from the patenting process. You know, what the next steps are within each of the steps between the idea and a fully granted patent. I'll turn it over now to Joe.
All right, so in general, intellectual property is where the government has decided to provide property-like rights for ideas, since you can't just put a lock on those like you could with real property. It breaks down to patents, copyrights, trademarks, and trade secrets, as mentioned. Patents are protection for inventions. They offer you the right or exclusive right to produce it for 20 years in exchange for disclosing your invention to society. Copyrights are to protect literary works, dramatic, musical, artistic, or other creative works. They are to protect the expression of things, though, not the idea. So if you publish a scientific journal or something, you can keep somebody from publishing exactly that, but you can't keep them from using the information in there. Trademarks are to protect the distinctive words, names, symbols, or devices that businesses use to distinguish themselves from others. This comes more from fair trade than it does from the other IPs, and is to protect consumers by making it so that they can be sure of what they are buying. And then trade secrets are a recourse to keep your secrets from being released by foul play if you've been taking reasonable measures to protect them. So the patent system has two basic goals. They want to stimulate invention, and they want to get that knowledge out to everyone. So it does that by making sure that you have a return on your investment of inventing something by giving you the exclusive right, and gets the knowledge out there by requiring that you share that with us in exchange for those. So a patent is the right to exclude others from making, selling, or using your invention, and it goes for 20 years. A note here is that it's the right to exclude others from making, not the right to make. So if you invent the next nuclear bomb, you might be able to get a patent for that, but you don't necessarily have the right to go making those. So what can you patent? It's any machine, manufacture, process, or composition of matter that meets the requirements of novelty, non-obviousness, and utility. Of those, novelty and non-obviousness are the real challenges because utility is a very low bar. An example of something that met that requirement is the toilet snorkel, which is exactly what it sounds like. It's a snorkel to put into your toilet drain in order to get air during a fire. Basically, that breaks down to, can it be used for what it says it is? And that would come up maybe in the case of if you're trying to claim something like a teleporter. We're going to go, you're going to have to prove that that actually works before we're going to give you a patent. So if you have an idea for an invention, what do you do? First, you're going to want to search it and make sure that it actually is new. If it is new, don't go telling everyone about it. Once the public knows about it, we no longer want to pay to let you produce that by yourself. So you might lose rights. If you have disclosed it, tell an attorney as soon as possible, and that's your next step, is get some help from an attorney. To help us, when you go to an attorney, things you might want to have ready are having decided whether you actually want to file for a patent. Do you need that protection, and is your idea new? All your search results, providing those to us gives us a big jump start on our patent searching. And then you're going to want to create an invention disclosure, which is basically telling us what your invention is and how it works so that we can draft your application.
So We'll continue by talking about a hypothetical, a kind of ridiculous hypothetical situation. Let's say you have come up with the idea for a chair. That's a little impractical for the folks in this room already sitting on chairs, but the idea is if you come up with something brand new that you think nobody else has come up with, what do you do? What are your next steps? An important initial analysis is to make sure that it is new, that it does seem like it is something that hasn't been out there yet, that no one else has thought of this or described it. So as Joe mentioned, do a search. Do a quick Google search or any other search engine, and then also look at perhaps at Google Patents, and we'll get into that a little bit more. But the idea is that when you come up with this idea, do a quick analysis to see if there are other related technologies, and then think about whether or not there's a commercial potential for it. You may have a great idea, but a great idea is only valuable and worth the patenting process if you think it is also commercially viable. It's a little hard to tell up front how commercially viable some things are. But if it seems like it might be worth protecting, then it's worth pursuing a little bit. So the idea here is that for a chair, it's easy to think about the structure. You've got the platform, often a back, and then a few legs, usually some sort of stability, whether it's 3 legs or 4 legs. Think about the way that you would describe this. We'd like to get you, whenever you're thinking about your invention and its description, think about a simple way to describe it that enables you to convey it in a way that somebody else could draw a picture of it, for example. So if you could describe it and its essential features, it should only take a few sentences, and then you can convey the idea through that text. The figures themselves will also help quite a bit. So if you have a drawing, even a hand drawing, you can use that as the basis for your description. But the idea is to think about how you describe it to somebody else. As Joe mentioned, try not to describe it to too many other people, but you do want to think about how it could be described. So for that, we have a template that we're including in the slides of just some high-level features that we'd like you to include in this description. The more detail you provide, the better. Often this initial description that you come up with becomes the basis for the patent itself. So when you do talk to a patent attorney or anybody about this, they often use that very text that you've come up with. So try to come up with more than one-word answers for this. So this is the content. This slide lists a few of the contents that we always like to see in these invention disclosures. A summary can be just a sentence or two that describes generally what it is. Drawings are great. Again, those drawings can be used to form the basis of your description. And then the detailed description here. This detailed description has a few important points that we'd like to talk about. Certainly, what is it? What are you inventing? How is it structured? And why is it important? What does it do? That is the second point. What is it for? What purpose does it serve? Is it just for seating? Is it for decoration? Things like that you want to answer for yourself and then try to describe as thoroughly as you can. How you would use it is important. Again, it could have more than one use, but that also gets to whether or not it's going to be a technologically viable function. As Joe mentioned, teleportation has its own set of uses, but the structure may be a little difficult to describe. But more concretely, a chair, of course, has a very obvious set of uses. The fourth point there, how to make it, is also important. This is a requirement, actually, of the PTO that we do disclose the way of making it, and in fact, we have to disclose the best way of making it. So there may be a few different ways to create a structure, a chair or otherwise, and we have to describe at least one of them, and then what we think the best method would be for that. Now, it doesn't have to be the absolute best method ever invented, but the way that you would make it, and then the best way that you think would result in the product that you're trying to protect. It's important to also consider the differences between what you've invented and anything in the prior art. A great way to get a sense for this is when you do your search, look for what's out there. See what other people have patented, what other people are selling. You can search on Amazon, Google search, and then compare what you're doing to what they've done. See what's out there and think about why your product is better. What is it you're doing differently? What distinguishes your product from the other products that are out there? This is important both for your analysis, but also at the patent office, because that's the question that the patent office is really trying to answer when you submit a patent. We'll get into the process a little bit later, but the takeaway for that difference is that the patent office is going to come back. They're going to try to find some products that are similar. They probably will do a Google search as well. And you need to be ready to answer that question: why is your product different and why is it better? So that's the importance of determining your differences from the prior art. It's also worth including, just for your own notes, who invented it, who contributed to the invention, the conceptualization of the product. That's a bit different from who actually made the product. So if you have one person who came up with the idea and a separate person, say a carpenter, who made your first chair, if the person just made it, then they're not an inventor, at least for the patent office purposes. They may be a business partner, but the inventors are just the people who came up with the idea, who came up with that concept. And then finally, who have you told? You know, if you've told anybody about this, as Joe mentioned, the disclosure, a public disclosure, even a private disclosure, can create problems for you. The U.S. Patent Office has about a year of grace period that they allow for a disclosure, but the sooner, the more of a secret you keep it, and then the sooner you talk to a patent attorney, the better off you'll be. So keep track of who you told and when to the best of your abilities. Yes, I see you have a question.
I think I understand what prior art is. Oh, it's live. Okay.
Yeah.
Hi, sorry about that. So I have two questions, if you don't mind me interrupting.
Yeah.
First is, can you give just a brief description of what prior art is? I think I know, but I might not. And then the second thing is, with the disclosure, if you have a product that is already out in the wild and is being used by maybe over 100,000 people, like, how do I disclose that? Do I just say it's being used by this list of people, or is it widely used already and I'm just sunk?
Yeah, good questions. Well, prior art is a term that we use to refer to anything that is any sort of publication or product or anything else that's out there that is similar to your invention. So the prior art could be something as straightforward as somebody published a paper that describes your new method of creating a new chemical formula, or it could be a product on Amazon, or it could be a combination of products, and we'll get into that a little bit later. But the prior art, the idea there is that anything that was published or sold before your invention can be considered prior art and can be used by the patent office to try to reject your application. Another way to look at that is the patent office is going to do a search, come back and say, hey, we found this thing or these things, two or more things, that seem like when you combine them, make your invention. Tell us why yours is better or different. So anything that the patent office could find is considered prior art. Sorry, what was the second question?
The second question, I don't know. So again, the second question was, we have over 100,000 downloads.
Disclosure. Yes, sorry, yes. So prior art is, the disclosure requirement is anytime you disclose anything in any way, it forms a part of this disclosure. So if it's for sale, if it's being used by anybody, then that forms a disclosure that can be used against you as prior art, conveniently. The patent office is, like I said, there's a grace period. There are also carve-outs for if you're the inventor of it. The rule of thumb is, in the United States, you have about a year from some sort of disclosure, whether it's public, private, on sale, private offer for sale. It's about a year from any of those events until the point that you have to file. In most of the rest of the world, there's an absolute novelty requirement. So if you sell it today in the United States, then it's probably not patentable in Europe, for example. So a lot of other countries have this absolute novelty, very, very strict requirement. Here we have this 1-year grace period, but sooner is better. If your competitor files a patent on a product that you made, even though you made it first, you may be able to get the patent on it, but it takes time and money to deal with the patent office for that. So filing a patent is always better. You can also file a quicker provisional patent that gets you at the patent office, it gets your name in there with that filing date, so that can help you prevent a disclosure. So when in doubt, talk to a patent attorney, say we've got a product coming up or a conference coming up, we'd like to talk about this, what do we need to do to be protected, and they can walk you through it. So those tie in well together. Yes, we have another question. We'll get a mic.
Thank you. My name is Masood Yunus. I'm a co-founder of a local startup here that is SaaS-based. So my question is going to be about software.
Yep.
There's a lot of confusion around what is patentable in software, especially in SaaS. There's a platform like Amazon or Google. Then there's a mid-tier. Then on top of that, you put your workflows in. Then you weave them all together to create your own unique tool set. What can you patent out of it?
That's a good question. So software patents are a bit of a complex issue. Essentially, software is patentable. A methodology that is implemented in software is patentable. They've had a bit of an uphill battle in the last 4 or 5 years. It's getting better, but it's always improved by having some sort of physical tie-in. So if your software is a way of improving the way an electric vehicle charges, but it's pure software, but it affects something that is physical, then you can tie those together. When it comes to software as a service and other sort of multiple layers of software where you're working your software on somebody else's platform, then your software is still patentable, but to the extent that you require someone else's service or another patent, then it may be, you can secure a patent on it, but you may not be able to practice it. As Joe mentioned, the nuclear example, maybe you can have a patent, but you may not always be able to practice that without getting a license from the other patentors. So it's a bit of a complex matter, but it's worth looking into. And anytime you have those multiple layers of patents, then always check to make sure that you have some sort of clearance to use that. You can always file a patent, but yeah, the use is a different inquiry. But good question. So I'll talk a little bit more about the patents themselves. I'll breeze through a few of these. This is just a high-level overview of what's in a patent. This is sort of a table of contents for the next few minutes. The patents themselves, they're the application process, the criteria for that the Patent Office uses for judging whether or not you are entitled to a patent, a little bit about searching, and then a decoding of the documents themselves. This is just a high-level picture of a patent. If you Google patents or if you've looked at any patents before, you'll see they often have a cover page, some figures, and a lot of claims and the specification. Often we recommend taking a look at the figures. If the figure looks like something you've done, then it may be related. The claims are the most important feature of this, and we'll talk in detail about the claims in a few slides. This is a very high-level overview of the process. Essentially, you submit a document that describes your invention. It'd be great if you used a template or something that relates to the earlier questions that we asked about who made it, when, a sentence or two about the high-level overview, and then a deeper description, perhaps a few figures. The next step is examination of the Patent Office. They usually pick it up within about a year. The total pendency, the average pendency, is between 2 and 3 years. And then at the end of that, you'll either get a patent or it'll be rejected in the end, and you may have to either file a different patent or you may pursue a different application. Typically, that only happens when the Patent Office finds other products or patents that are very similar to what you've done. So the rejection is, it can be the end of the line, or it can be an opportunity to modify what you've done and distinguish it from what else is out there. The Patent Office's function is more of it's better seen as a gatekeeper for all the patents that are out there. Their job is to make sure that no two people end up with the same patent or patent protection for the same invention. They don't want two people fighting over that. So their job is to have a repository of all the patents. When you submit something, they look at it, they examine it, and they try to distinguish it. They try to find something that's similar. So again, they say, these other patents that we have look similar. Tell us why yours is different. So in that gatekeeper function, they give what's essentially a thumbs up, thumbs down in the end But there's always a way to further distinguish your application. So this is a bit more detail about the process itself. This shows just essentially you go from your new application to this pre-examination process where they have an intake. They make sure you've submitted all the documents that are required. Then there's this examiner search function. They have their own search engine, but it's not too dissimilar from Google Patents. If you do a Google Patent search for some terms, you'll often find a lot of what they're looking for. But in the end, it only matters what the examiner finds. So they're going to do their own search, and whatever they find will help drive that examination process. In the examination process, they're very likely to come back with a patent or more than one, and they'll say, these look similar to what you're doing. Tell us why yours is different. The way that you distinguish, the mechanism we use is the language of the claims. So the claims define the scope of the patent and in its entirety. So if you have a patent that seems too similar to what's out there, then they're asking you to modify your claims, to change it a little bit. Usually you try to claim as much as you can. You try to claim a chair or all chairs that are ever made. But maybe they find a four-legged chair and you say, okay, but mine has 3 legs or fewer. And that's the modification that helps you get to that allowance. But it's that exchange, this loop that's shown on the slide, that is the process of reexamination and amendment to that primary claim. You can keep going through this process a bit, and then eventually you can appeal if you disagree with the examiner. There's a lot of other ways to work with this, but essentially that's the process. We have one more question?
Yeah, I do. Sorry. So taking the chair example, say that you developed the 3-legged chair, but somebody else developed the 4-legged chair. And then that 4-legged chair developer wants to say, you know what, I think this works great with 3. Can that 4-legged chair then, because the 2 products are so similar, but can that original and that 4-legged chair person got the patent first? Can that 4-legged chair person create a 3-legged chair because they have a patent? It's like...
Yes, that's a good question. So the way that the...
Thank you for trying to understand what I'm asking.
No,
Great.
It's a good question. It's a nuanced question for patent attorneys that even we struggle with a little bit. The simple answer is that your patent will protect what you have, assuming you've claimed it correctly, which we'll get into the magic words for that. If you claim it correctly, your patent should protect what you have plus other things. So if you've patented a chair and somebody comes out with a chair plus cup holder, then you still have protection as long as you've protected that chair. They can add a cup holder or anything else to it, but if you have that base of protection, then you have the better position. So a person who's patented a 4-legged chair who removes something likely isn't able to infringe your patent because it has a separate mechanism. The support mechanism is different. So the difference in what you add or take away makes a pretty big difference, but also the ability for you to modify the claims during prosecution matters. So the idea of the patent, this whole process, this loop, is that when you get to the end, they want to finalize the scope of your claim. So they know exactly what your patent is. You've agreed to tell other people about your amazing invention in exchange for exclusive rights. But the agreement is that you're going to tell people exactly what the bounds of your claim is, exactly how many legs on your chair, so that other people know that, hey, if I make a chair with 2 legs somehow, then that's different. So that's the intent. You're trying to publish it, and in exchange for that publication, you're going to get exclusive rights to just that thing. So if you wanted to file something different, like a 2-legged chair, then you'd have to file something else, and then there'd be the whole examination process, and you go through that process again. But yeah, that's an important feature.
Just as a quick interjection here, that does, for the chair example with the number of legs, does depend a lot on how your claim is actually written. As you're trying to patent something, your attorney's job is to make it as broad as possible, while the patent office is trying to make it as narrow as possible. So if the person with a chair with 4 legs was able to make their claim something like supported by a number of legs, they probably cover all of the 3. If they had claimed 4 legs, then the 3 probably might get around it.
Yes. And we'll get into some of the claim language as well here in a couple slides. Like I said, that language is important. This is another example of a potential invention. This is more just a thought experiment. If you had a rocket and you realized that every time the rocket blasted off, when it came back down, it crashed hard to Earth, then you'd want to protect that in some way. One way to protect that could be to use a parachute. In this example, the parachute is deployed upon the expiration of your propellant. So as soon as your rocket is used up all of its propellant to move it up, then it deploys the parachute, which helps slow the descent. So the idea there is not only the structure that, as shown here, this is a patent image of the structure, that particular structure that enables that functionality is important, but also the steps, the idea that the deployment of the chute happens only after the propellant is exposed and specifically in response to that. So it waits till the end, and at that point, that's the next step. So when you're thinking about these, it's just a better example than a chair because there are multiple steps and they're sequential. So the sequence of it might be important for patentability. The invention disclosure form, this is a form that relates to that rocket example. Essentially, this is just the idea that you have your basic description, you can come up with a title, sentence or two to describe it, who the inventors are, whether it's been disclosed, and then a general description of what you're doing. So these are, if you're looking for something like this, our slides are available, but also if you just Google invention disclosure form, something like that. Nolo makes a great book on this as well, but anything related to invention disclosure forms, that's where you'll find this information. When do we switch over? Let me know. Okay. So this is all based on this disclosure. Again, that form that we just showed you. We had this example that we showed you with the rocket and then the chair description. They're very simplistic descriptions of this, but they're not too different from what we see. Our clients, big or small, all use this idea of this invention disclosure form, give it to their inventors, they get some information back, and those forms are used both internally by the attorneys and other people evaluating. We use them at LegalCORPS when we evaluate what we're going to patent or move forward with, and as attorneys, we use them as well. So these invention disclosure forms are used widely, so they're very helpful. And next to Joe.
And that's just an example of the patent for the application they were talking about. So for actually doing the claim itself, there is a few different parts of it. The first introduction bit is a high-level description, which basically that is kind of to try and narrow down what yours gets compared against. You might be able to keep your guitar strings from being compared to suspension bridge cables. But that's not exact science, and yeah. Then there's a transition word. There are 3 that exist. There's comprising, consisting of, and consisting essentially of. You want comprising. If your lawyer is using anything but comprising, you might want to think about a different lawyer. That is the open one that allows for protecting against other features. Consisting of is closed. It means it is exactly what you have written, nothing more, nothing less. If they can add or remove anything to it, you no longer cover that. Then you are going to break it down into the different features of it or elements, and you're going to write it as long of a run-on sentence as you've ever written because it has to be 1 sentence per claim. So going back to the criteria, it has to be novel and non-obvious. Basically, what this breaks down into is novelty is, does this exist already, this exact thing? Then there's non-obvious, which is, can we make this as an obvious combination of 2 things that are already out there? And we'll go through a bit of examples of that in a sec. For a search example, once you have your claim written, take the keywords of that, especially the ones pertaining to what is new about your invention, and do a Google of those, search those and see what comes up. This is an example of the results you might get if you go on Google Patents. You may come up with things that are related or not and have to refine it and go back and forth till you're pretty sure it doesn't exist out there. So for an example of novelty, here we have you claimed the filled-in car. In the prior art search, there is a filled-in car, so that is not novel, it's already there. Example 2, your claim is the outline of the race car. That is not in the prior art that shows up, so that would be novel. For obviousness, again with the car there, it is no combination of the things over there, so that is non-obvious, whereas this is the corded car outline and the scooter. Both of those exist in the prior art, so yours is an obvious combination of those.
Yes, so to recap that, the novelty and obviousness analyses are things that you do intuitively. As you look at, as you search for things, you might find things that are similar, but again, when you're looking for products that are out there, then you're looking to answer the question to yourself, is what I'm doing different? And if so, is it different in a meaningful way? If it's a minor change, like you're adding a cup holder to a seat that really doesn't affect the functionality of the seat, then maybe it's not a useful difference. Maybe it's not enough of a difference to distinguish your patent or to be worth separate patent protection. But you're always looking for whether or not it is different. So again, the novelty question is whether or not you can find one thing that is different from what you're doing. And then obviousness is, using those car examples, can you put together a number of different things that would be different? For example, if you had an electric car and a separate Vespa, and you put those together, does that automatically give you a Lime scooter? Probably not, but that's the sort of combination that they'll be trying to make. That's the argument you should expect from the patent office anyway. So they're always going to take a bunch of things and then try to combine them. And then your job is, again, primarily to say why yours is different or why it's better, or even why those things couldn't be put together. Now, in that electric scooter example, that's not a great example because clearly they can be put together. But the idea is if there are differences or if their proposed combination doesn't work, you need to think about why yours is different and why it's better. Your patent attorney will do their best to answer those questions, but you as the inventor are the expert. You are in the industry, you know the invention in the industry and your competitors better than anybody else. So be sure to share that insight. You've thought about these questions, so we welcome your help. We always welcome insight. This slide shows that once all of that has been taken care of, once you've worked with the examiner to help distinguish your invention, to modify those claims so that it does distinguish from the other products that are out there, then it's a thumbs up, you get your patent. That process, again, the pendency of the patent, the exchange of the patent office, usually takes 2 to 3 years. There are some ways to speed it up a little bit. It can even take longer than that, unfortunately. Depends on how aggressively you're fighting for something. If you need a patent very fast, say for investment purposes, it's possible to, say, file track 1. There's programs for this. Your patent attorney knows all about this. You have to pay a little more money because the patent office loves their fees. So if you pay a little bit more money, then they'll examine it faster and you can get a patent very quickly. Now that patent that you get would be a fairly narrow patent, but it's still an issued patent. And then that can be used as the basis of investments and the basis of a continuation or further patent. So after you get your patent, you can always file something else that will be pending at the patent office, and you can expand the scope. So even if you did say, I'm only going to have a chair with 4 legs, and that's all, then you can file another patent that says, hey, I want a chair with a support system, like Joe mentioned. And then later on, you can clarify if that's for a 3-legged chair or a separate stool that swivels, something like that. You have that time to consider how to change those claims. Now, this may be especially useful if you know that your competitor is coming up with something, but you're not quite sure what. You're not sure how many legs they're going to land on in their final product. Then you can change your claim during the pendency of your patent to better target the competitor. You can also do it to target your own products, but you can also target your competitors. So keeping that open in that continuation is useful. This slide shows the patent themselves. Again, if you do any Google search, you'll see a lot of patents that are out there. They all have the same exact format, and this can be very useful. When you find something on Google Patents, it'll show you the most important parts first, but all of this information that's in this PDF are all on that main page. So you can find it there on the page. You can see who the inventors are, when they filed it, and whether or not it's been assigned to their company or a different company, so you can get a sense for what other legal entities, other companies are involved, and you can get a sense for how long it took them to prosecute this. Every patent page also has access to the PDF, which is what you see here. Every PDF has on the front cover all of this information put in this nice, neat organization, and then leads right into the figures and then into the rest of the application. Thankfully, Google Patents and a lot of others put the claims front and center. They usually have the description on the right, left, my right, and the claims right next to it, so you're able to see that. Again, the claims are the most important feature, so always look for that to describe the scope of what you're patenting or your competitors. And then finally, this is a little bit more detail about the features that you'll find in it. The most important things are going to be the filing date, essentially, and the inventors. In an earlier slide, we mentioned that the duration of your protection is about 20 years from filing. This can be somewhat shortened or lengthened depending on how prosecution goes, but the rule of thumb is look for the earliest filing date. Here it's shown a little bit on the left toward the middle, but look for the earliest priority date and then count about 20 years from that. So that's a rough ballpark of how long the patent has been in effect. If the patent has expired, you can always check the status. If they didn't pay the maintenance fee, they didn't want to pursue it, then it's likely if the patent is no longer in effect, then you can probably use that patent in your products. You should always ask an attorney officially to make sure that it's safe to use. But generally speaking, once a patent expires, then anyone is free to use it. So even though you have the right to a 20-year exclusive term, it's not guaranteed. It's only guaranteed for as long as you pay the patent office. Again, they love their fees. So look at the patent. You'll see another date that is the date of issuance. That affects damages and other things. So that's an important date as well, but the priority date is the most important. So always check priority dates when you're looking through these patents, especially online. That's a high-level overview of everything. We'd be happy to answer a few more questions. Yes, we have a question.
Yeah, thanks for the talks. I'm debating right now whether I need a patent for this project that we've just officially started to get funding for.
Yep.
And curious on your thoughts. Back to assessing whether or not there is a novelty idea or not. Yep. I'm hearing a lot of technology or material pieces to what makes most patents necessary. Yep. Is there like a method, let's say a cognitive method that can get patented? My example is, in your example, you were talking about cars, but there was different types of cars going into that category. But the word cars is already an ambiguous term. Yeah. And then there's different shapes and sizes and features. So do you have to patent cars, if that's what the concept is? Or are you patenting different elements of different vehicles? So in our project, we're in healthcare, and there's a model that we're looking at, which is yoga. Yoga is a term that's not patented. Anyone can use the term yoga, yep. But to business can use yoga within their company name. So how does one have a different, let's say, practice or a method? Is that something today that we have to patent, whereas thousands of years ago they weren't patenting that type of terminology? I hope my question's coming through.
Yes, yeah, there's a number of great questions sort of built into that. As far as the terminology itself, the terms are often protected by either trademarks or copyrights. The copyright, as Joe mentioned, protects the item that you have, the actual written word. Coca-Cola is a great example. It's a trademark and a copyright. But if you have a word like yoga, that word is probably too generic. Like you mentioned, it's been used forever, so you probably can't get either a copyright or trademark on that. If you make it somewhat more unique, like yoga power or core power yoga, maybe that's protectable by a trademark or a copyright, depending on how it's configured. The copyright protects the thing that you've created. As soon as you write it down, you have some copyright protection for that. The trademark protects your brand. So if you have a combination of words that you'd like to use for your branding or your product, that is an ideal candidate for trademark protection. Trademark protection is it has its own examination process. The term of the trademark is valid for as long as you protect the trademark, but it also only protects it if you protect it. So if somebody starts to use your core power yoga for something different, then you have to say, please stop using this. So that's trademarks in the oversimplified nutshell. As far as the patents and the language itself, you have to make sure that what you're patenting is described clearly to anybody that reads that claim. The nice thing about patents is that the phrase we use is you can be your own lexicographer. You can make up words in patents. You can absolutely make up any word you want in a patent as long as you define it. If you have a made-up word and you don't define it, then the examiner will say, I don't know what this means, please explain. Typically, that means replacing that word with a description or some other clarification. When it comes to the car example, you want to describe, it's easier to describe a specific set of features. You have an airbag deployment system that reacts to some inertial sensor detecting a crash. But separately, if you have a method, like the multiple steps of detecting a crash, and then in response to that, determining if you've crashed hard enough to require a deployment of your airbag, and then in response to that, deploying the airbag. You can have a multi-step process for that. So you can protect some methodologies in what's in the method patent. There are some things that you can't protect, like things done purely in the human mind. So if you're able to do it, say, you can do the entire calculation using a pencil and paper, or just, let's say, circle all the first names in a phone book or something like that. That's something that could be done either in your head or the pencil and paper. Those are a lot harder to patent. Sometimes you still can, but it all depends on the specific methodology you're trying to protect. The more complex it is, the better. And like I said, anytime you tie it in with something with a sort of a tangible output, like you're using these names to give somebody a reward, or you're using these names to charge a phone and only in response to them being verified, something like that. The more specific you can be, the better, but that's all a part of the examination process. Yes, I think we have another question.
We're going to do a quick online question
Oh, yes,
and then get back
please.
to the room.
Yep.
Hi. So the question is, if I were to need a chemist or a mechanical engineer to invent and know about a process, how can I keep my idea safe without the chemist taking it before I can patent it and know the process myself? In other words, or in general terms, how can I protect my idea before knowing what the exact process is so that when I do find the process with the help of a professional, my idea won't be stolen by them?
So for that goes more into contract law. You're going to want to make an agreement with them that they are inventing that thing for you. If you have that, then they will still be the inventor, but it will be assigned to you once it's filed.
Yeah, and to that, and also if you have them in preview of contract, if they're your employee, then there's probably a clause in the employment contract that covers that, where they must assign anything they do. It's a separate question that if you have come up with the idea and they're just the ones that are what we call reducing it to practice, if they're actually synthesizing the compound or if they're building your chair, then just the building act is not the same as the conception. So they're not an inventor. The question of inventorship is important, but the best way to protect it is make sure you have a contract. That's a good idea. Always get those in place early. And also make it clear that you've invented this, and then write that down somewhere. Email yourself, just have some sort of record of what you have thought of and when, and maybe talk to a patent attorney, but also separate that from what they've come up with, because it's possible that you came up with a first invention, and then a separate filing is the combination of you and that person. So, but they're good questions. Try to answer those questions certainly earlier than later. Make sure you have it very clear with your workers. Yes? Yes, we have a question.
Hi, thanks for the panel. My question is a little bit more philosophical. I'm curious, lately in some mainstream entrepreneurship in tech worlds, most notably with Elon Musk coming out as being fairly anti-patent, I'm curious to hear what your guys' thoughts are as experts in the industry in how much of the patent process right now is more stifling innovation than promoting it, and at what point do patents get in the way more than they actually help?
Yes, that's a good question. You want to try? Okay. So the argument, I think there's a valid argument for the idea, especially in software patents, that let's say you have a number of software patents that are out there, some algorithms that are being used. Then how do you know if what you're drafting, let's say you're coming up with your own set of software, how do you know that your software is different enough or that you're not infringing on someone else's patent? That's a difficult question, and for that reason, the Patent Office has pushed hard against a lot of these pure software patents, these software-only patents, things, again, that can be done in your head, even if a computer does it better. If it can be done through a series of steps, then they're disfavored by the patent office, which means they're more expensive and harder to get through, and your resulting patent is a bit narrower. Whether or not it stifles innovation that's a very good question. For software, it ends up being a little bit harder to know what you've done. When it comes to other products, though, the individual contributions to things, as long as you came up with on your own, if you're coming up with an idea, then it's often the job of the entrepreneur, not the inventor, but the managers to make sure that what you're doing, your product, is going to be able to be sold, is different enough from what's out there. That veers into a bit of a legal question, but it's a question that's also sometimes answered by your market share. So for example, if what you're doing is different from what your competitors are doing, there's a strong argument to be made that is different enough that there's a market need for it and that it's different from everything else out there. There's a chance that you'll invent something, that you'll come up with a great idea, and then you'll find that it's already out there, and that patent office is actually great for helping you determine that. The patent office, again, their function as a gatekeepers to make sure no two people have that patent. So the first thing they're going to try to do is search for that, and if they find someone else that's done something like your process or like your product, they're going to tell you right away. And essentially, if they give you the patent, if you get that thumbs up, they're telling you that at least the patent office believes that you're in the clear, at least for practicing that invention that you're different from everybody else that's out there. I think there are some valid arguments to be made for stifling of some creativity and some invention. So it ends up costing a little bit more. The give and take on that is that it also promotes the distribution of ideas. Again, the patent office system is that great exchange of you disclosing your product, your system. You're going to publish it. You're going to tell everyone how you do what you do, and they're going to give you exclusive rights for 20 years for that. So there's some advantages to the system as well. But you're asking good questions, and you should always keep an eye out for those things as you're drafting these. Make sure that you're keeping an eye out for what's out there and try to file early, even if it's a basic idea, so the patent office can tell you generally how close things are, and you can get a better sense there.
Question related to that or building on that. For every startup out there, they're always sensitive to capital.
Yep.
And when you start thinking about patents, they can be quite expensive, as we know.
Yep.
And I really have a two-part question. One is, what's your differentiation, or how do you think about foundational patents versus patents that may have a little bit more marketing value, and how to invest in that? And then the second piece of that is, when you are looking at those foundational patents, there's multiple ways you can look at it. Do you have a landmine strategy? Do you have a picket fence strategy? Or are you trying to create a complete moat? You're certainly not going to use that strategy early on, but just thinking through that process of how do you get from a startup and a strategy to a longer term, if you do have growth underneath of you, how do you actually protect the core foundation of the business itself?
Yes. Yeah, that's a good question. It's a complex question because another way to phrase that is the patents that you want should always begin with your core product, what it is that you're doing, and what you'd like to protect. So this begins often with a single patent, maybe a small number that is within the budget to secure that base of IP protection. After that, then you can start to think about how to proceed with those. Like you said, you can have a sort of a landmine approach or a defensive approach where you're patenting only the things that you're doing, and that it'll protect your core business. You could also extend that through the use of continuations or patents pending at the office, where you modify the claims to better target your competitors or to target things that you might be moving into. You may not know exactly the direction your business is going, but if you think it might move in that direction, then you can keep a patent open and modify the claims as needed. And then when you get into some of the broader patenting schemes, like if you have enough, if the budget supports that and then a little bit more, then you can look into whether or not you're going to start filing a lot more patents related to the surrounding area of technology. This is very industry specific. So there are some areas where, like wearable technology, Fitbit devices, things like that. It's a patent thicket. There are so many patents out there that you end up patenting such a tiny fraction of what's out there that it ends up being a very expensive business, and it's often not worth the investment. For any patent, whether it's a foundational patent, defensive, offensive, you always have to ask yourself, does it make sense for your business? Is this a good investment? They are expensive. They're often 10 grand or so to file and prosecute to the first steps. The entire life of the patent may be 20 to 30 grand, and that's for each patent. You can let some go and save some money in the long run, but each of those should be something that makes sense for your business and helps protect what you're doing. We don't want you to file patents just so that we get a little bit more hourly billing. That doesn't help us if you're going to go under as an entrepreneur. We want it to make sense for your business. So always think about whether or not each incremental patent provides that added value sufficient to justify the expense. They can be a huge help, especially in investments. Investors always want to know if you have a patent of some kind or some kind of IP, so they can be a huge help, especially in the first few patents. As you move beyond that, then it becomes a broader strategy discussion with your attorney that we'll make sure that it fits your needs and then the local environment. If your competitors are filing a lot of patents, then you may need to file more. But yeah, it's very specific to your industry as well. But always keep an eye on that. Keep an eye on the budgets, whether or not it justifies it, and then how thick that patent area is, if it makes sense to file. Yeah. I think we have time for another question.
Yes, I wanted to know how you handle funders who say, tell me everything about what you're doing before I'll give you any money, but you're trying to reach a stage where it's before it gets patented, and so you really can't tell them anything, and they won't sign an NDA. So where's the line as far as buy funder? I'll go find somebody else who will play,
Yes.
how it should be.
Great question. So don't be Theranos. Don't pretend something that doesn't exist. If you're trying to make something that you think might exist, it's okay to explain things at a high level, but it's also okay to not tell them. You don't have to tell somebody about how you do what you do. If you can tell them what you do, or better yet, if you can show them that you can do that thing, whatever that is, or make that product, that's usually enough. It's a good idea to have at least a provisional patent on file. They're a lot cheaper. They end up being $1 grand, $2 grand, somewhere a lot less than 10 grand. So having a provisional patent will at least get that protection, so you can say that it's patent pending and you can have it on file, and you don't have to show them what that is. Their provisional patents are not published, so they don't need to know about that necessarily. We always discourage folks from sharing their patents if they don't have to an investor, but if the investor needs to see it, if they won't move forward, then you could share it. As long as you have a patent on file, you have protection for all the ideas in there. So it's belt and suspenders is first patent, that's the most important, and second, the NDA, that is something that you draft or you come up with, so it's on equal footing. That's the next step. So start with the patent, secure an NDA, and then you can talk a little more, but only disclose as much as you need to. Always be careful. It's your idea. It's worth protecting.
Again, I'm going to just bring up again, you have great questions, and intellectual property brief advice clinics, check out the LegalCorps website for the dates and times. Right now, they're all virtual, and so we are doing appointments in advance. So it's my email, iap@legalcorps.org, and say you want to participate in a brief advice clinics, you can have a consultation with the patent attorney, and all of these questions are questions that regularly come up. And if you want to be specific and say, okay, this is why this is a problem for me, it's confidential and privileged information when you're talking with an attorney, so you are not disclosing anything. And that attorney can probably get you down the road to the next step. This is the next thing for you to consider, or the next two things for you to consider. So again, brief advice clinics, LegalCorps offers them. They are transactional business attorneys, or the IP specific are patent attorneys, so they can address pretty much the whole spectrum of intellectual property.
I think that about wraps it up for us, but we're happy to answer more questions if you like. Thank you.